motion for default judgment due to the government not rebutting the affidavit put in place by Heard and not responding to any of the motions that Heard has filed in a timely manner. To rule, this court has discretion to grant this motion in accordance with the common law due to no rule being in the Texas Code of Criminal Procedure that governs such a motion. See Texas Code of Criminal Procedure Art 1.27. Common law governs. If this code fails to provide a rule of procedure in any particular state of case which may arise, the rules of the common law shall be applied and govern. See also All Writs Act 28 U.S.C. 1651. The Supreme Court and all courts established by Act of Congress may issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law.
Now, so like I like this. Okay, so the reason why I like it is because now you done already told the state law they got something that's dealing with the common law, and it ain't nothing in play as far as statute and everything like that. The common law still should apply. And then you turn it around and you using the federal law saying that the All Writs Act triggers and allow the same thing on the federal side, where if it's something that's there that's not in play, that don't allow somebody to do something, say like for instance, you in a trial or you going to court and everything, and the court is telling you, well, you got counsel, and because you got counsel, you can't argue nothing in the court, but not knowing that under Federal Rules of Civil Procedure 24, the next of friend will allow somebody else to come in and intervene on your behalf. Okay, so under the All Writs Act, the All Writs Act will allow that to trigger for somebody to come in and intervene on your behalf. So when they come in and intervene on your behalf because your lawyer is not doing something that they supposed to be doing, then that person can come in, and all they have to prove is, one, they're a family member, two, that they don't have you don't have access to the court. So because you don't have access to the court, they can intervene on your behalf, and then say your lawyer is ineffective while the process is going through to allow you to win your case.
Right.
But they don't think we should raise to that level of understanding to know the rules and regulations and things of that nature to deal with the circumstances that we face with.
Exactly. Because I remember they trapped me up in there before I caught my Fed case, when they trapped me up there. Because first I beat them using that UCC 1308 affidavit. The next time I went in front of the same judge again on a dope case or whatnot. They trapped me in the county jail for like a year. But while I'm up in there, I'm going to their law library is vast, and a lot of niggas don't even know it. Because when I went up in there, I started looking. I'm seeing the state UCC laws up in there. Everything's up there. I'm like, bro, I can walk my way up out of here just staying up in here and doing this, that, and the third. So boom, I go up in there and I went ahead and I start filing everything. I had somebody filing shit from outside, but they knew they never wanted me to get outside to get to a computer.
Right.
That was their whole thing. So I started doing everything from up in there, and by the time I done walked through there, then they tried to provide standby counsel, but the trick that they were doing, they was using the standby counsel to go up in there and argue to present everything to the court, so they can go ahead and fabricate it and do whatever they wanted. So instead of me going out there and doing everything, they just keep me in the bullpen.
Right.
But I started stalling on that bitch, and I was like, nah, bitch, we ain't finna play no stupid ass games like that.
Mm-hmm.
Either I'm going out there, you know what I'm saying, or nothing's gonna be said, you know what I'm saying. I'm gonna show that y'all violating my rights. Before long, they had to pull me out there, and I basically went ahead and we went back and forth, and I was going by using reversible error to go ahead and destroy them, basically showing that I'm not this person right here. There was nothing that they can do. But the next time, it went from 25 to 99 years down to, man, we can time serve this right now and all that, man. Fuck no. We ain't doing none of that shit.
Right.
You know what I'm saying? Yeah. Mm-hmm.
Yeah.
But you definitely right.
Yeah. So, like I said, you threw that part in. That was perfect. I like that. I'm gonna continue.
Argument. Amendment. C. Schmerber v. California. 384 U.S. 757. 767. 86 SCT 1826. 16 LED. 2D 908. 1966. In this instance, Hurt, who was told that his blood would be taken, refused and disclosed in specificity that he did not consent to such drawing of his blood, was ignored and told that such consent was not needed. It must be recognized that the Fourth Amendment right to be secure against unreasonable searches and seizure extends to incarcerated prisoners. See Heydrich v. Hunter, 449 F3D 682, 5th Ser 2006. Hurt further presents an affidavit in regard to such fact of non-consent to the drawing of his blood, which construes to make the prima facie case. See United States v. Kiss, 658 F2D 526, 536, 7th Ser 1981. Indeed, no more than affidavits is necessary to make the prima facie case. See also United States v. Lukowski, 462 F3D 965, 8th Ser 2006. The government is required to the direct product of unconstitutional conduct. See Segura v. United States, 468 U.S. 796, 804, 104 S. Court 3380, 82 L2D 599, 1984. See also Nicholas v. State, 502 SW, 2D 169, 172 173, Tex. Crim. App 1973. However, Hurt also asserts that he was not read his Miranda rights at any point before his arrest, which is provided in his affidavit of the facts and must be held to exclude any statement that he has made which the prosecution would seek to use for purposes of incrimination. See Miranda v. Arizona, 384 U.S. 436, 445, 1966. Our holding will be spelled out with some specificity in the pages which follow, but briefly stated it is this: the prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. It is further asserted by Hurt in his affidavit that no traffic ticket was ever issued in regards to the car accident that took place, with no ticket being issued to Hurt showing that he caused the accident and violated the Texas Transportation Code. Hurt is hereby the victim who cannot be the suspect in a criminal action. Thus, no reasonable search for his blood for purposes of alcohol can be made, making not only the evidence that results directly from the unlawful search and seizure that must be excluded, but also any evidence that is discovered as a result of the primary illegality. See One Son v. United States, 371 U.S. 471. 487 488, 1963, Nicholas v. State, 502 SW, 2D 169, 172 173, Tex. Crim. App 1973.
Now I like how you went back and put it all together, right?
Mm-hmm.
And so when you look at what you put in the very beginning of your motion to dismiss, okay, where you put
suppression motion that I just did?
no, your lack of jurisdiction motion, okay. Under your lack of jurisdiction motion, you use the regulations, and because inside the regulations that you use, you told them what they can do when they came to him and asked him questions. You get what I'm saying?
Right.
The only information they could take from him at that particular point, further than his explanation, was his telephone number and this and that and the other, not his blood.
Right.
You see what I'm saying?
Yeah.
So because they went to another step, when he didn't get no citation for the ticket for the crash itself, then they can't go beyond that. You understand what I'm saying?
They jumped over some stuff.
So they jumped past what they were supposed to do. Not only did they jump past what they were supposed to do, they didn't follow the regulation. Because they didn't follow the regulation and do what they doing, now what they done is, it's called an abuse of process. Under abuse of process, the element to hit them on or to show is that they They doing it for profit. Okay? Okay? So every time they come in the courtroom, guess what they doing? They billing. All the information when they sit down and write what they writing, they billing.
Yeah.
You get what I'm saying? So so now at that particular point, because they done what they done, right?
Right.
Under 44, 42, 1983, and 81, there's a civil suit.
Damn.
Suit.
Okay? Now, in the civil suit process, you use the regulation. Under the regulation, it's telling them what they done and what they done wrong. Now, in that, also in that situation, even when you doing what you're doing, okay, what I would do at this particular point, I would do one more motion, okay?
And what's that?
That's a motion for a declaratory judgment and an injunction. The reason why is you making the court deal with the regulations down there. Okay? So when they deal with the regulation down there, see, because what you're doing is now you put them in a trap. The trap you put them in is, if they do it, it's over. If they don't do it, everybody in the courtroom can get sued.
Oh, wow.
That includes the judge.
Because they are a part of it.
Everybody. The reason why is because now they didn't follow the regulation.
Right.
You get what I'm saying?
Right.
And because they didn't follow the regulation, they all hit. See, and this is the part that we tend not to focus on or pay no attention to. See, they think they got authority to do whatever they want to do and just do whatever they want to do. But see, they also put laws in play to stop all of that. But what we have not been doing,
hitting them in their pocket.
Them in their pocket. And if we start hitting them in their pocket,
they'll stop doing
what they're doing. That's just like this.
Cause
all these federal lawyers that's out here, that's getting paid with all that money, stop paying them money. Stop even going to them. Go to let the public defender deal with what's going on. When you get to that point and start making them do that, right? And ain't no money going to their pocket, guess what? They gonna turn around and they gonna start applying the law correctly.
Right.
On every level.
Right.
You get what I'm saying? See, because they ain't gonna be able to get the money that they've been living off of. And putting a bunch of dudes in jail. Like all these high-priced guys that's big up here. The part that's funny to me is they give all that money to them, and then all of them take a goddamn plea to something that they ain't even in law.
What was even more funny, that's just like, man, I give an example. This nigga I know named D-Cuz, know what I'm saying? He went ahead and paid $20,000. When I was in the Fed, I was
too.
Yeah.
You know? That's like, I did a case. It was the first case I ever won in the Feds, right?
Right.
I read 5,000 transcripts. I asked my man for not a penny. Okay? We went and turned it and gave the documents to everybody that was in the law library that thought they had some understanding in the law, and asked everybody for their opinion. They said it was some trash. Okay? Now, filed the stuff in the court. A printy came out. The judge turned around and asked my man, and I ain't gonna say his name, but he know who his name is. Cause in his paperwork, it said, prepared by jailhouse lawyer, and my name is Otis Paris. Okay? For y'all who don't know who I am, now y'all do. Okay? So when he did it, we sent it in. He went and took it around. He sent it home to his lawyer, to some lawyers on the street. The lawyers on the street asked him to come back to me and ask me what why did I do it the way I did it?
Ask you.
And I said the reason why I did it that way is because I wanted them to answer it the way I wanted them to answer it. Okay?
Right.
So when Apprentice came out, everybody on the compound, and we was at Milan, Michigan. Okay?
Yeah.
My man said, everybody came back and said, no, they should take it and change it. So he turned around and he sent to the court and said to the court, he wanted to amend it. The judge sent him back and told him, no, leave it like it is.
Dang.
Okay?
Judge respected it, huh?
Then the prosecutor came back and said that the court should deny this and this and that and the other, but we agree that he has ineffective assistance of counsel and a conflict of interest,
Not alone,
and that
dude.
he should be remanded. Right?
Right.
Ain't nobody ever seen a prosecutor come back and agree with the defendant. And they was all shocked. They was all shocked. Now, at this particular point, now everybody want to jump on the bandwagon. Okay?
Yeah.
Now this is the part that was crazy and funny. Now, he was sent for remand in 2001. This is the bad part about it. He didn't get remanded until 2006. I went from Milan to Jessup, Georgia, to Elton, Ohio, before he got remanded. I got to Elton, Ohio in the beginning of 2006. In the beginning of 2006, he had his people reach out to me and tell me he just got remanded and he'd be in court in a couple of weeks. He gave me his lawyer's telephone number, told me to reach out to his lawyer and talk to his lawyer. I reached out to his lawyer. His lawyer told me he didn't want to have a conversation with me. He's not going to talk to nobody and everything like that. And my man had already gave him all the information. So what I tried to do to circumvent what his lawyer was trying to do, I turned around and reached out to his sister and gave the information to his sister to send to him, to actually take to the court.
Because she could step in because she family.
And help him. It got lost in the translation. And he never got the opportunity to put the other information in front of the court.
Right.
You know. And then the lawyer went in and bombed it, killed it. I mean, sunk, dead, and lost everything that was supposed to be done. But you know, they do that, and that's because they're part of the problem.
Right.
You know, and then they think that a person sitting up because he ain't got a piece of paper to say I'm a lawyer. You know what I'm saying? That what you got in your head don't mean nothing.
Yeah.
You get me? But at the same time, I had that very conversation with a lawyer. The lawyer sat and told me, you know, you trying to be a lawyer. And I told her, I turned and looked at her and told her in her eyes, I ain't trying to be no lawyer. It ain't nothing to be a lawyer. It's about what you understand.
Yeah.
And guess what
The lawyer ain't the motherfucker that's doing all the work. It's really paralegal.
But guess what?
The only thing y'all doing in there is just going in there and presenting it. That's it.
Exactly. But guess what she ended up doing though? She ended up taking my argument and incorporating into whatever it was needed to be done. Why? Because when her client went to sentencing, right? And some of the people out in the world will see it and know it. He went to trial. He was charged with 20 keys or more. Guess how much time he got? He got 6 months. Why?
Oh, yeah.
Because his lawyer.
You turned it into what's below misdemeanor?
A simple possession. An infraction.
Yeah. An infraction. Yeah.
So he went to sentencing. Started saying what was written in the paperwork that I put together, and the judge said, "Hold on, I'm gonna stop right now, because I don't want no hybrid representation at this particular point. Say, go back, sit down with your lawyer, and have your lawyer come back in and say what needed to be said. He went to trial, lost. His mandatory minimum was supposed to be 5 years, based on what people think that they being charged with, not knowing that every charge has a lesser included offense of simple possession of drugs, and if you ain't got caught distributing it, the weight does not come into play.
Yeah.
Okay.
Yeah.
So he ended up turning around. He ended up with 6 months.
Damn.
Yeah. 6 months.
Yeah.
Yeah.
Mm-hmm.
But like I say, you know, I like what you're doing.
Yeah.
I like what you're doing.
Okay.
You know, like I say, keep doing it. And
B. Motion to dismiss. Heard asserts that he is illegally imprisoned in violation of the 4th and 14th Amendments of the U.S. Constitution and Art 1 2, 9 and 19 of the Texas Constitution.